The Dershow.
The cross-examination has to be strategic. See if you can figure out a way of getting the prosecution to have to stand up in court in front of the jury and correct the testimony of their own witness, because that's required under New York law. If your own witness testifies in a manner that you believe is false, remember, he's not your client, so there's no lawyer-client relationship. You have an absolute ethical obligation to stand up and say, Your Honor, I'm sorry, but I have to correct the record now. What Cohen has just now said is inconsistent with what he told us on this and this date. And those issues, and then you can also try to find out if the prosecution has notes. You can again ask Cohen, did you see them taking notes? Who was taking notes? And were they taking verbatim notes? Did they record the conversations and the sessions with you? Now, the prosecution will claim some kind of work product, but under the Brady violation, under the Brady decision, the Supreme Court, anything that's exculpatory has to be turned over. And so I do think that it's important not to just do the traditional, typical cross-examination. Didn't you lie? Didn't you do this? Aren't you lying now? Did you lie then? Are you lying now? That's standard, and juries understand that, and witnesses are prepared for that and know how to answer those questions. What's most important is what happened behind the scenes. What's most important is the preparation that went into the answers, the making of the sausage. And that's what has to come out on effective cross-examination. We'll see. We'll see if that happens. That's the way I would conduct my cross-examination if I were Trump's lawyer in this trial. Trump's lawyer seems like an able person, but too many lawyers have a rote method of cross-examining. They've been doing it for 30 years. They may have lost most of their cases, but they've been doing it for 30 years. I remember once somebody wrote something in a brief about the Fourth Amendment, and I was asked to look at it. And I said, that's just wrong. And the lawyer said, I've been putting that in my brief for 20 years. And I said, yeah, how many appeals have you won? None. So they repeat the same thing over and over again, whether they win or lose. And so I think cross-examination also tends often to be rote and often to be just because it's been done before. And like a good suit, you don't want to buy a good suit if you can afford it off the rack. Cross-examination has to be tailor fit. You have to ask yourself, not how do we generally cross-examine, but how do we cross-examine this witness in front of this jury, in front of this judge? And one of the things you do, by the way, is you plant appellate reversible error. You ask questions that you think might be objected to, and the judge might sustain the objection. And you make sure that you preserve those errors for review. I mean, another one of the questions that could be asked, obviously, that's a standard question, is, do you regard yourself as an honest person? And there's no good answer to that for Michael Cohen. He'll probably say, well, I used to be dishonest, but now I'm honest. Are you lying then or you're lying now? Are you aware what the judge recently said about you, that you're a deceptive person? Do you think that's an accurate description? Again, there are no good answers to those questions. But every lawyer has their own style of cross-examination. Do you walk right up to the witness? Do you confront the witness? Do you do it in a laid-back way? Everybody is different. I did one of the most effective cross-examinations, the most effective cross-examination I ever did in my life. I disclose verbatim in my book, The Best Defense. I cross-examined a policeman and got my client acquitted as a result of the cross-examination of a murder. It was a rare cross-examination because my client had tape recorded the policeman. The policeman was trying to flip him and make him into a cooperating witness. So we were able to use the fact that there was a tape recording of some of the conversation, but not of other of the conversation. So, every cross-examination has to be different. And we'll see how this emerges.